Good evening, everyone, and welcome to another in the series of continuing legal education offerings of the New York Law School ADR Skills Program. Tonight, we're very fortunate to have two members of the task force that have been working on the NextGen bar exam to address not only some of the broader changes that may be in store for us, but in particular to concentrate on our area, which is the introduction of concepts of client counseling and negotiation into the bar. From Northeastern Law School, we have Hemanth Gundavaram, and from New York Law School, we have Kris Franklin. And Hemanth, I wonder if I could just hand it over to you and start learning myself.
Yeah, absolutely. Well, thanks for having me. As Peter mentioned, I'm a professor at Northeastern University. I run the immigration clinic there, and I'm the associate dean for academic affairs. So I've been working with the NCBE for the last 3 years on the NextGen bar exam, and I just wanted to talk about what the changes are going to be, and then I'm going to turn it over to Kris Franklin to talk about to show you some specific examples of how the bar is changing and particular questions. So I'm going to just share my screen to kind of pull up this PowerPoint to kind of give you a sense of what is changing. So it's the NextGen bar exam. This came from, a call from many people to make the bar exam more practical, more skills focused, especially with the law schools leaning more into simulation courses and clinics like the one that I run. So coming soon to a jurisdiction near you. Now, July 2026 is the debut of the NextGen bar exam. Just to give you kind of current states that have adopted the bar exam for 2026. It's Connecticut, Maryland, Missouri, Oregon. For July 2027, Arizona, Iowa, Kentucky, Nebraska, New Mexico, Vermont, Wyoming. So I looked at these just, this list is changing. Even when we created this PowerPoint 2 weeks ago, I had to update it an hour ago with these changes. So different states are going to be adopting at different times. July 2026 being the first set. Now, if you kind of do the math on July 2026, that is current 1Ls. So the 1Ls, first-year law students who are in law school now will be taking the July 2026 bar exam. So in those 4 states, at least at the moment, they would be taking the NextGen bar exam. So I think it's important just to kind of understand the phased rollout of the NextGen bar exam. For 2026 and 2027, states can choose the current uniform bar exam or the NextGen bar exam. So NCBE will be running both tests in 2026 and 2027. As you can see, many states have not decided on 2026 yet, but beginning in 2028, only the NextGen will be available. So states can choose to take the 2026, to do it in 2027. In 2028, they would either have to do NextGen or create their own bar exam. So if you can kind of see this setup of the sunset period, 2026 would be both exams, 2027 is both exams. In 2028, it'll be only the NextGen exam. Alternative paths, right? So if states want to do something other than go through NCBE for their bar admission, they have until 2028. They could do UBE in 2026 and 2027, do the UBE, and then in 2028 come up with something else. So some states are considering experiential education as a path to the bar. The ABA's Council on Legal Education and Admissions is asking for comments currently about alternative paths. So what does the test do? What do the designers say? Here's what's, to me, the exciting part of the test. It is more skills focused, 7 foundational skills were going to be tested, and they're organized into 4 broad skill areas. So issue spotting and analysis, investigation, and evaluation, right? So that's always been on the exam, although I think there's going to be a more emphasis on investigation and evaluation than previously. 2, which is sort of why everybody's here, client counseling and advising, negotiation and dispute resolution, client relationship, and management. 3, legal research. 4, legal writing and drafting. These changes, the way we think of these changes at the bar exam is that these changes are going to affect the future and the past. And so what I mean by that is all of the steps after the bar exam. To me, the preparation for the exam, as well as the changes backward to what the law school curriculum, how the law school curriculum will change as a result of the exam, is one set of changes. And then in terms of future, then the attorneys that will be practicing law will have a different set of skills, potentially based both on preparation for the exam, but also the changes that might occur in law school because of the bar exam. So the NCB description of what the exam is going to look like, 40% of the exam will be devoted to standalone multiple choice questions, with 4 to 6 answer options and sometimes 1 or more correct answers. Initially, the questions will look like the previous MBE, but stability between scores for current and next-gen exams are important, and it will have a variety of multiple choice question types that will increase in the future. 25% of the exam will be devoted to integrated question sets. This is the sort of major difference in the bar exam. Kris will go over an integrated question set, but the idea of a question set, these integrated question sets, is to more closely mirror the practice of law. That involves a number of things. One is one fact pattern with multiple questions, rather than each multiple choice question being about a different topic. The second thing is an overlap of subject areas. So in a section, you might have 6 questions. And the nice thing about the NextGen bar exam is those 6 questions all aren't about one topic. You might have a criminal law question, followed by an evidence question, followed by a negotiation question, followed by an ethics question. So the fact pattern evolving allows the tester to test multiple areas of law and multiple skills. So much different than the sort of torts question, civ pro question, evidence question. Common set of facts, Kris will show an example of that, but in addition to doctrines on questions will focus on drafting or editing of a legal document. So skills, but also overlap of subject areas. So here's kind of an example or a visual representation of what I mean when I say an integrated set. An integrated item set can bring in both multiple subjects like evidence and criminal law, but also multiple skills like issue spotting, analysis, investigation, negotiation, client counseling. In terms of the bar exam and the timing of 2026 versus 2027 and 2028, a lot of people are focused on, well, what year is my state going to adopt this new kind of exam format? And I sort of say, don't necessarily consider when your state is going to adopt it. There will be lawyers practicing law in 2026 who will have taken this, regardless of your state. There are going to be attorneys who have taken the 2026 NextGen bar exam. Same thing with law schools. There's going to be students who, regardless of whether the state, so Massachusetts that I'm in, if Massachusetts does not adopt 2026 bar exam, I will have students who will go to another state and take the bar exam, and they might be taking the 2026 exam. So, so important for everybody to kind of be ready for 2026. The last sort of set of types of questions are the performance tasks, and those require completing a task like a first-year lawyer or a newly licensed lawyer in a realistic situation. So that's creating documents or writing a memo, but those are performance-based tasks. Okay. So Kris, I'm going to turn this over to Kris now to talk a little bit about what this could look like. As to this part, kind of finishing up, what I'll say is I have been excited about the reformatting and changing of the exam to make it more practical, more reliant on skills. The kind of negotiation, client counseling, all of that part, it's those are typically classes in law school that are simulation based. So the exam is not going to test people in a simulation, of course, right? What it's going to do is put people in a scenario where they might have to analyze strategy, considering negotiation, alternative dispute resolution, and client management. So ultimately, the questions are strategy based, but they are in the context of these ADR principles. So I'll let Kris take over to show an example of what one of these integrated item sets might look like. And I know, let's see, I will let you take over the PowerPoint. Oh, you're muted.
I'm going to share, and essentially we are integrating the same set of slides, but we're going to do it together. All right, so one thing that I think is worth noticing, that a lot of this stuff is in flux as we're going on. So we are working with material that's been released by the National Conference of Bar Examiners, because that's what they're publicly saying is happening. But if you follow these conversations, there are many, many, many details, that some of which there are answers to, but they have not been publicly released, others of which are still evolving. In some ways, the problem that I'm about to go through is what the NCB is telling us all is the goal and the objective of where they would like the NextGen to go. There has been in some of the publicly released discussion an implication that the NextGen is going to get next-genier over time. In other words, even when the first iterations of the NextGen are released, because everybody knows that this is ideally a kind of radical sea change in how people are going to be assessed and tested for licensure, there is an expectation, and this is where we're going to go toward the end of our discussion today about what does this mean for legal education and how do we expect law graduates training to look different in the future, ideally as a result of some of these changes. The idea is that the exam is going to get more like this over time. Even when people are taking the NextGen is going to have more of these questions that are a little bit more integrated as time goes on. So I'm not going to ask you to sort of to go through every bit of it. I'm certainly not going to read you the slide, but I'm going to just pause for a second and give you a problem, give you an opportunity to read the screen. I'll talk about it a little bit in a second, but for now, it'd be helpful if you just sort of read this yourself. So as you can see, the first thing that we're getting is the typical, a client walks into an attorney's office and the attorney is asking questions. Now, obviously, these questions are going to have to be very abbreviated. That's one reason why these are not really simulations. Obviously, we can't have real life clients, but even within the realm of what can appear on paper, what you'll notice is they're kind of bare bones compared to what the legal educators that are present in this room might do even in a simulation class. But it is still laying out the details. You can tell right from the beginning that obviously we're going to be talking about a construction contract. It's not hard to imagine that there's going to be something that goes wrong in the construction and some kind of dispute between the parties. The interview goes on, and keep in mind now, I'm going to give you a second just to read this one. This is also still an abbreviated version even of the problem. The entire problem that's been released is available on the National Conference of Bar Examiners website. We will give you the link to that website toward the end of this, but just take a second to keep reading. As you're taking a look at this, notice we've got a couple of things going on simultaneously. One is this is obviously a contract, and so there's going to be a problem with the contract. But now we suddenly have two contracts. The parties could have constructed a modification of the initial agreement Anybody who teaches or practices in contracts areas would know that there's some interesting questions with respect to contract modifications. If this had been a UCC deal, for example, you wouldn't necessarily need new consideration to modify the original one, whereas you would in a common law. That's a frequently tested nuance in common law of whether consideration is required for modification. One hope, and the NCBE has said this directly, the bar examiners have been clear about this. One hope that a lot of people have is that the new bar exam, because it's focusing so heavily on so many different skills, may spend a little less time in obscure areas. The bar exam has a bad rap, or maybe a good rap, depending on your take on it, for testing the details of the exceptions of things, rather than for focusing on some of the more basic things that everyone would expect practicing lawyers to know. If you notice here, this is some pretty basic stuff. There's a pretty clear agreement. There's another agreement, and there's obviously going to be some kind of conflict about that agreement. So this is a pure question of contract law. Now, notice the next thing they give you. I'm going to give you. I'm skipping, leaving out the actual areas of contract law. The problem could either expect that test takers would know the contract law, because the basic, what are the requirements for forming a contract, what might constitute a breach, what defenses there might be, have always been things that we would expect test takers to know. They will remain things that we would expect test takers to know. But there is also an expectation that people could be given specific rules. Here, they might or might not be given some rules of contract law. But because the next thing that's going to happen in this dispute is that we're going to have some litigation, they do need to know what the procedural rules are. So the next thing that the bar exam would do would be to give us the procedure rules. Now, this is the one that was released. It's named Franklin. I would like to think it's named that purely because of me. And so I'm taking complete credit for that. I don't believe that's true, but that doesn't mean I'm not going to claim credit for it anyway. Notice that what they're giving us is the specific rule of civil procedure about what constitutes an appropriate way to craft a complaint. Now that matters, because up to now, all we were thinking about was contract law. But obviously, if there's going to be a dispute about contract law that reaches the point of litigation, there's also going to have to be some litigation documents. And in fact, that is the next thing that we're given, which is a complaint and jury demand. It's not a particularly well done complaint. You might notice that some of the stuff is left out. If you look on this slide, you'll see facts enumerated number 19 through 29, which is everything pertaining to the actual contract substance. We're told is to assume is pled correctly. Therefore, we incorporate by reference all of the materials that we've read before previously about what the actual fight is between the parties, and we get some detail that seems to pertain primarily, in fact, not to the initial agreement between the parties, but to the second agreement that they reached when the homeowner decided to add to the project by including a fish pond. And remember that was not, they could have done it perhaps as a modification of the initial agreement, but they did in fact seem to have done it as a second contract. So test takers are given this complaint and jury demand, and notice that what the problem is they have to find 5 mistakes. Now, the test takers have asked them to specifically to identify those mistakes, pinpoint exactly where it is, that's so that it can be graded fairly efficiently and hopefully consistently from test taker to test taker. So they identify what the paragraph is that includes the mistake, describe the kind of mistake it is, and correct it. That's a thing that we've never seen in the bar exam before, except perhaps in the performance test part, is to see people actually performing correct legal work. That's not a thing that has traditionally been a thing that we tested for licensure. We've simply tested their knowledge of the doctrinal information. So here the test specifically defines a mistake could be there's a mistake of fact. You've actually saying something wrong, a mistake about the substantive law, or a violation of the provided procedural rule. So in fact, it could include all of this. Now, if you had the entire problem set, you would see that this problem does actually include some information about the substantive contract law. But immediately the test taker has to do what a lawyer would do, which is to understand contract doctrine and to understand this client's facts pertaining to the contract, while at the same time do what a litigator would have to do, which is immediately sort of evaluate whether the complaint is properly pled. Because of course, the first thing a defense attorney wants to do is to probably get the complaint dismissed not on the substance, get it dismissed on the procedure. If the procedure is somehow not properly followed, the substantive issues will still remain. Defense attorneys usually like to try to keep things as well defended as they can. And so they might hold off and not raise the substantive complaints until the complaint were properly pled. So here, just like in real life, the lawyer would have to understand the substantive contract law, understand the procedural law, understand what proficient practice is. Now, keep in mind, the bar exam as a licensure test is seeking to test minimum competency. It is not seeking what would be expert, superb, perfect practice. It's simply seeking to say what constitutes sufficiently effective practice that the person deserves to be licensed to practice law. So all the teachers among us who would like to say, no, but you can make it better this way, you can make it better this way. That's a thing that we should do as legal educators, but it's not what the bar exam is doing, because the bar exam is asking what meets minimum competence standards for appropriate licensure for the practice of law. So here a mistake has to be genuinely a mistake, not simply I could draft it better, but there's a problem in the way it's drafted such that it could create difficulty. Now that problem could be it doesn't meet the procedural rule. That problem could be it misunderstands or misidentifies the substantive contract law. Or it could be the lawyer didn't understand what the client was saying, or did understand and willfully misrepresented the facts as the client was giving them, and therefore the facts that are laid out are not correct. And notice that every single one of those would constitute a mistake that could be identified. Now, it's probably going to be true in this problem that careful analysis would actually reveal that there's more than 5 mistakes that might be identified. So, for example, a grader for the NCB might be given a list of, I'm just making this up, but could be, say, 8 problems, and they would be identified by paragraph number, and they would be described as what type, and they would be told which ones are not mistakes that commonly people might mistakenly identify as mistakes. But the lawyer's job, the law graduate's job, is to go through that and find each one of those things. Simultaneously, then, the law graduates need to understand 3 things, only one of which has previously been tested when we all took the bar exam, for those of us who are licensed now. They need to understand the substantive law. They need to know legal doctrine, and they need to know it very clearly. They may be given some of it, they won't be given all of it. That's always been tested, and it's always been an important part of what lawyers need to know. We also know, though, that lawyers can't possibly, even the minute after they take the bar exam, know all the law there is to know. It's always been a little unrealistic to assume that anybody could, right? The goal of the bar exam is simply to say, everybody who's practicing law with minimal competency should have enough of a sense of the general law in their jurisdiction, even in areas they're not going to become expert in, so that they can see and identify problems. And if they're not aware of or have sufficient expertise, refer their clients to people who are, or develop that expertise. So that's kind of what the domain knowledge has always been. But this problem is doing something else. It's insisting that they also have practical knowledge. They should be able to look at and read that client interview, probably have back in the back of their head, well, what question would I have asked? What question, what is the information you need from the client in order to craft a complaint? They have to be able to assemble and understand and work with all of those facts. Then they also have to be able to move seamlessly from contract law to civil procedure law in order to apply that rule to identify in that complaint what is properly pled and what is not properly pled. This would lead naturally for a good lawyer to figure out, how do I respond? Do I want to put in a motion to dismiss? What am I going to base it on? What are my options strategically? And tactically, what is the best choice for me to make? That's stuff that lawyers have always wanted, young lawyers to do, and that for generations we've lamented that the bar exam frankly did not test on any of it. It only tested on the subject matter domain knowledge of contract law and more recently civil procedure. People may not be fully aware that civil procedure is actually fairly new in the National Bar Exam. It was only added, I'm going to want to say about 10 to 12 years ago that it became a subject matter test tested on the multi-state bar exam. It was always usually part of individual states testing in their own information, but not part of the national test. So now they have to be able to move seamlessly between one another. If this is what law graduates are going to need to do in order to take and pass the bar exam, that raises a whole host of questions, which is, how are we going to teach them to do that? How are we going to prepare them to do that? So I want to turn now to basically just a more open conversation. And now I would invite you, if any participants who are watching this have questions, it might be, we certainly can't get to a lot of them, but if there's questions you want to ask in the chat, please do. But I'm going to just pose for both of us, and I'll toss it to you first, Hemanth.
If I may, this is Peter, if I may interrupt you, Kris, just to make sure that everybody watching fulfills their CLE obligations, we sent you a link to a form on which we are asking you to fill out 3 code words, and I will give you the first code word now, which is uniform. So the first code word for CLE is uniform. Both of the speakers have made a point of hoping that those of you who are online will please pose questions in the chat field. And I know that we always say that, but considering the people who are talking and what they're talking about, and particularly considering the folks who are attending this evening, I really do encourage you to pose concerns or questions or challenges that you have in the chat field, because we have some people who might be able to address these topics in a provocative and helpful manner. Kris, I'm sorry to interrupt. Please go ahead.
No, that's perfect. That's exactly what we did. And I know there will be further interruptions for people to make sure that we have the CLE compliance that everybody needs. But my first question is, I sort of just made a fairly broad claim, which is that I think that this better replicates the skills that beginning lawyers should have than prior versions of the bar exam have done. But I'll throw it back to you, Hemanth. Do you think that I'm right about that?
No, I do. And I you know, one of the things that I think I've thought about a lot over the years is the exam and the sort of a couple of things, I think. One is the amount of pressure we put on students and graduates during the exam to memorize an immense amount of information, almost an incalculable amount of information on multiple subjects, which is so different than what it's like to practice law. The idea that you would ever sit down for 8 hours and answer questions about 12 different subjects in detail without being able to look at any materials is so antithetical to how we practice law. I look everything up, and what I tell my students, no matter how sure you are of, you know, in the clinic, for example, how sure you are of how many days you have to wait to get an employment authorization document in immigration, you should look it up because it might have changed yesterday. You don't know. So the emphasis away from memorization toward actually being able to apply skills, I think is a welcome change, both because it more mirrors the real practice of law, but also because what I'm hoping is that it changes the way we teach in the law schools themselves. So that's one aspect of it. The other interesting thing, you know, there's been kind of people on all sides commenting about the NextGen bar exam. I've seen people say, well, it hasn't gone far enough because it's not open book, and, you know, a bunch of other things about how, you know, we shouldn't even have a bar exam. And I understand that perspective for sure. And I think that's why there are those alternative paths to the bar exam. But certainly I've seen a lot of criticism that the questions people have seen, that it's too easy, the new exam. And that criticism that I've come from is seeing people say, attorneys say, well, I can answer these questions, so that means it's not a good exam. And you know, for me, I think that if we're testing a minimally competent, newly licensed lawyer, the idea that every single practicing lawyer should fail the bar exam, because I certainly if I sat down today to take the UBE, I would fail. I feel very confident about that, but I am certainly minimally competent, at the least. I hope. And so, you know, to make the exam actually something that a good practicing lawyer can sit down and take without having memorized things, because they have the skills and the ability to be able to do and answer these questions, because it's mirrors what it's like to practice law. To me, that's what we're looking for. And the idea that it's too easy because people who are lawyers can pass it doesn't make a lot of sense to me.
Yeah, I was asked a couple of years ago to review a set of questions in contracts. And I've been teaching contracts for 15 years. I'm working on a contracts textbook right now because I'm joining a team that's already established a contracts textbook as a new author. I sat down and took them. I think I'm a fairly good test taker. I've always done pretty well on standardized tests. I was very pleased that I think I scored 69% the first time I took it, which was higher than I expected. That might be almost passing. And I mean, this is one thing that I feel like we don't really know about the NextGen when it's released. The goal, for people who have looked carefully at the topic scopes, the goal of the NextGen is to say, because we are expanding so drastically the number of lawyering skills that are expected, that we don't need to get obscure with the subject matter itself, because there's enough challenge in what's going on. And people who can quickly read things and feel like they know the answers when they're not under tight time pressure and when their licenses are not depending on it, forget how much more challenging that is in test taking conditions. So the goal is to do that. Whether that's actually what the questions will look like over time, that remains to be seen, because the only thing that is publicly released are the things that are publicly released. But I would submit to the people who think it's too easy that, first of all, I entirely agree that this should be a thing that practicing lawyers should all pass. Otherwise, why are they practicing lawyers? But secondly, we forget, once we know how to do things, how astronomically difficult it is in the beginning. The simple fact is that the vast majority of law students finish a civil procedure course having never read a complaint, finish a contracts course having never seen a contract. This stuff is sort of easy for practicing lawyers because it's easy for practicing lawyers because we practice law. But try teaching a first-year student who's never taken an evidence course and doesn't really understand how litigation works, the parole evidence rule. The parole evidence rule is extraordinarily difficult to learn in contracts because it is a technical and difficult rule, but that's not the real reason. The real reason is because people have utterly no context for it. And the goal over time is to actually provide a legal education that gives that context so that some of this stuff is not brand new and is not something that has never been seen before by graduates.
Kris, I wonder if I can just share an inquiry from one of our attenders who read my mind. I wonder if you wouldn't mind going back to the slide that had the complaint on it, and does that slide include some of the mistakes that the test taker is expected to identify? In other words, could you show us the type of mistake that you're looking to identify?
All right. Well, first of all, it says let's start with the first one. The initial contract signed by the homeowner included a landscaping plan. Well, now the first thing that we're going to have to do is go back and read the interview. Now, I will say, because I wanted to make this stuff that we could see in a slide, there are parts of this problem that are omitted. And so I'd have to go back. I don't even remember whether we included the part of the interview that answered that question. But that is a knowable and find outable thing. But the only way to know it is actually to go back and review the interview, right? So if we had the complete interview, that's the first thing that we should review. I don't know why that's a fact that needs to be alleged. I guess it needs to be alleged if we're going to reference the landscaping plan. But in fact, if the contract included the landscaping plan and it was included as an attachment to the complaint, I don't think it would even need to be alleged as a fact. But I don't know whether that's properly pled or not, which means now the next thing we need to do is to go look at the rule, right? So let's see. The rule says a party must state its claims or defenses in numbered paragraphs, each limited as far as practicable to a single set of circumstances. In other words, that's just telling us how to do it, and that there shouldn't be compound thoughts, and each one needs to be discreetly and individually laid out. A later paragraph may refer by number to an earlier paragraph in the same pleading. Okay. Later pleading may refer by number to a paragraph in an earlier pleading. Okay. If doing so would promote clarity, each claim founded on a separate transaction or occurrence and each defense other than denial must be stated. So all this is really telling us essentially is how to number things. Now, there might be other parts to the rule, but the most important part that I see here is a party must state its claims or defenses in numbered paragraphs. What that's going to presume and presuppose is it has to be a legitimate legal claim, which means you need to have a contract action. You need to have a basis for saying a contract was breached or not complied with in some way. And these need to be the correct parties that have the right to bring it. And the statement needs to comport with that. So far, it feels to me like it does. So I'm not convinced we found a mistake. If anybody thinks that we have found a mistake thus far and I'm missing it, please let me know, because I might well be doing so. All right, next. While the plaintiff was completing work pursuant to the initial contract, the defendant requested that the plaintiff construct a fish pond. Therefore, they entered into a second contract for the fish pond for $20,000. Do we see any kind of mistake there yet? As far as I know, once again, we'd have to go back and look at the interview to see whether or not this is consistent with what the interview said. But my memory of the interview is that it is consistent, because the lawyer asked what happened. Now, notice this would be a mistake if, for example, they had decided to modify the initial contract rather than to create a new contract. As I said before, they could have done either one. And there could be some significant difference in the requirements if it was done as a modification of some kinds of contracts. Although since it's a contract for services, there actually aren't any differences in what the requirements would be for a modification versus a new contract. All right, plaintiff completed construction of the requested fish pond on such and such a date. Now this one is obviously going to be contentious, right? The rules require that you state a claim. The claim, here we say they completed the construction of the requested fish pond. We can't know if they completed it unless we know exactly what was required, what the fish pond involved, and we know that it was in fact completed pursuant to those requirements and expectations, which I suppose is telling us now why we were told in number 18 that the copy of the landscaping plan was included. But notice that landscaping plan would not have said anything about the fish pond, because that landscaping plan was entirely relating to the initial contract that didn't include the fish pond, since the fish pond was a later agreement. So we still don't have enough information to determine whether 32 is an appropriate allegation or not. 33 says, defendant acknowledged that the fish pond was completed as requested. Did they? Hemanth, do you remember that? Because now I'd have to go back and look.
Yeah, I don't remember. But one thing I'll say is that these questions are available. I'll put this in the chat just so because I know there are a lot of other questions in the chat. So the sample questions are here, and then the ones that Kris has been going over are specifically the integrated item sets. So to kind of I think Jean's question, this might be a way for everyone to kind of go back through on their own time and maybe check that out. What do you think?
Yeah, I mean, the thing is, in fact, you would need to go through the entire thing to find exactly what the mistake is.
Yeah.
Because here, I mean, the thing that I see as the biggest problem is the defendant acknowledged that the fish pond was completed as requested. We need to check, you need to check in different places, right? Here we need to go back to probably the client interview to find out whether we have that is a properly asserted fact. Because if the client never stated that they had that acknowledgement, this is improperly pled. It may be that the fish pond was completed, but this is actually sort of stating that there was an admission that it was completed, which is going to be kind of a problem if the interview does not support those facts. When the plaintiff I'm reading 34 now. When the plaintiff billed the defendant for the fish pond, the defendant stated that she would not pay for the fish pond. My problem with that one is that it doesn't say, it may be true that she said that. I don't know that I think that that's particularly well pled, because it doesn't give us a cause of action. It doesn't state what the reason was. It appears that she's withholding payment on the fish pond, not because of the fish pond, but because of some disagreement with respect to the health of the oak tree that was entirely and only the subject of the first contract, not the second contract that was only about the fish pond. So there's a lot of details of like what should be pled and what shouldn't be pled that I apologize. We did not want to give everybody, so much information. The slides would be overwhelming, but that we would be able to work out if we looked carefully at the slides.
I know, I can see that, and I can see that it's a little bit unfair to just take it off the slide instead of what's on the website. But an awful lot of us who teach mediation or negotiation would be looking at this and saying, well, is the fact that they didn't engage in direct negotiation prior to initiating litigation, is that a mistake? Is that a flaw?
Yeah.
Well, I want this opens, of course, a can of worms, but it's a can of worms that I hope we can discuss. A contract professor might affect their teaching of contracts by considering this, but a negotiation professor might see the whole problem differently.
Yeah,
well, one of the things that NCBE is doing is for all of these questions and that are being created regularly by professors and people at NCBE is pilot testing these questions to see when so they've been going to different schools and having people take the exam and answer the questions to see, are people sort of seeing what we see, right? Because these questions are a little different than the kind of multiple choice questions where it's like, this is absolutely the answer, that it's like, find the mistakes. Is pilot testing to see, are people kind of picking up on what is being asked and what is being expected. So that's one thing. I think that's allowing the questions to become more fine-tuned in a way that kind of integrates exactly what the person who's kind of creating the questions in groups is trying to look for. In terms of the second question, I'm seeing it in a few places about, what is being tested, and then also like, what might that look like in terms of negotiation classes versus like integrating that into the 1L curriculum. I would say, to the extent that for doctrinal courses, what the hope is, although this isn't from NCB, this is just me as someone at a law school who's kind of in charge of academics, is thinking about is, to the extent, can professors take the facts, all these cases that are on appeal that are years after the incident, and actually move some of the hypos, some of the kind of discussion, some of the conversations to earlier in time. So same set of facts, but earlier in time, what would you do? What would you do in this scenario? What's the strategy? Kris also mentioned that this is kind of the first run through of this exam. So to Donna's question, and I'm seeing maybe Athena's question, this idea of like, will it get into kind of really deep ADR and settlement principles? I would say probably not at the first instance. But I think as we go through future iterations of this, I can't imagine that some of those things like reservation points, like doing some calculations, might be part of what we're asking for on the exam. Because a lot of this is like, and Jean just mentioned this in the chat, a lot of this is like comprehension, reading comprehension, and also understanding the law well enough to be able to match what law you have to like the reading comprehension or the facts in the case. So the actual sort of strategic negotiation, how to counsel a client, those are, I think, a little harder to test. And I think that's might take a little longer.
Yeah, that's in fact, I think what's on all of our minds. So one would hope that one would hope that there would be a way to determine whether a young lawyer understands that it's important to give advice to the client before initiating litigation, and have the client determine what the benefit and risk of that would be, and enter into some course of action that might avoid that risk. And as you say, all of us, I think, find that difficult to assess. You know, it's a very difficult skill to determine, well, you do it well and you don't do it well.
Yeah. Well, and there's a question, I'll say, sorry, Kris, I'll just say one other thing. Just someone asked about, I think it's Myra, is it integrating these into 1L courses or taking ADR simulation courses? I would say a little of both, but I don't know that the things we're talking about here in terms of this version of the NextGen exam and the questions are going to be the kind that necessarily are fully developed by actually, or even necessary to take a simulation course like negotiation, because it's not, the exam's not going to be do a negotiation, right? It's going to be, what would you do in this scenario? And also the cost prohibitiveness at a law school to run a 15-person simulation course for every single student is just not there, right? So we have to sort of, I think, as a curriculum, start to reimagine, well, can we teach negotiation strategy and negotiation decision-making and negotiation analysis in a bigger course? Because
that's a question that Kris and I raised in the article that was sent around, that you know, there's one way of approaching this, saying, let's make everybody take a negotiation course, but there's another way, which is, let's make sure that the concept of extrajudicial attainment of the client goals is taught as part of the core curriculum. You know, as part of property, or as part of evidence that you, or civil procedure, that you consider non-litigating alternatives.
It's what we do now with professional responsibility, right? Professional responsibility could be a simulation course, but we don't do it as a simulation course for a number of reasons. We do it as kind of a bigger course.
So yeah, I mean, one thing that's worth remembering is, and this is where we do, we have a series of questions we want to talk about that is exactly asking this stuff about what does this mean for legal education, and what do we hope it might mean? What could it mean? Let's remember, the bar exam is still a standardized test, and the bar exam is seeking minimal competency. So some of the things that we might, particularly that ADR practitioners might most hope, are, I hope, going to change in legal education, but the bar exam can't do it, right? Minimal competency would be, for example, I teach family law, among other things, and you know, there are many jurisdictions in which you can't get jurisdiction for the family law courts if you are not pursuing some form of ADR in a divorce setting simultaneously or first. So in other words, you would have to make sure that you had attempted mediation before you could litigate a divorce. Now, whether that's pre or post filing varies from jurisdictions. Some of them you would have to do that before you could actually appropriately file a petition for divorce. Others, it would simply, you'd file the petition and then you'd be referred to mediation. But failing to plead that you have met that requirement in a contested litigated divorce, that's not meeting minimal practice. That doesn't tell you anything about what that would look like, whether it would be a good idea. And in a jurisdiction that doesn't require ADR for other kinds of litigation, it would not be a requirement that you attempt it. And so it certainly wouldn't be a requirement that you plead it, right? So in other words, there's some things that a standardized test can do. There's a lot that I think most of us would like to see that it can't possibly do. Although the hope is that at least it pushes us towards some things that are better. So I'm going to move on to some of the other questions that that we wanted to ask, because I feel like we're starting to get to them already, right? We started to ask sort of, what does this do about teaching? But I think one of the things that it says is, what kinds of education are people going to, you know, if the bar examiner is going to bar examiner, that's their job, is to create a test. What do legal educators want to do as response? And I've been to about as many sessions as I can attend of legal educators, deans, and others talking about it. It was interesting this year at the AALS, for those of you on the call who are not familiar with that, that's the the National Law Professors Conference that's held every year in January. This year was not the year of the NCBE. Last year was the year where everything was NextGen. Every conversation you went to was about NextGen. But depending on which room you were in, the NextGen kept coming up a lot, but people's ideas about what it might do about legal education varied a lot from room to room. For example, in one, I heard a law dean confidently reassure everybody present that this did not require any real changes to legal education because either the clinicians or the people who teach legal research and writing would take care of it, and therefore, sigh, isn't it great? Nobody else has to do anything different. That was a minority opinion. It is very much not mine. I suspect it is very much not the hope of people in the, on this call. You should be aware that that attitude is out there. But I would like to believe that that's a minority, because it's certainly true that the specific details of what makes for excellent practice are probably not going to be taught in your standard corporations course. But I do think the sort of, let's think about real life and how people actually practice, because that's what licensure is going to require, will change even the most traditional corporations professor to remember that rules about how corporations are formed are not the only thing that their students are going to need to know. At least that's my hope. Hemanth, do you agree with me, or do you think I'm a little too pie in the sky?
Yeah, I mean, I'm hearing all kinds of things between, I'm hearing, oh, it's not going to change at all, and then some people being like, there's no way I can do this. It's too much, right? And I think the truth is probably somewhere, somewhere in between that. But I do, and I'm seeing sort of what Donna wrote in the chat, about the class at UC Davis. I think that's the kind of class that could help people prepare for this. I also wanted to just raise something that I think is a very good point by Lydia. That there was only one DR strategy related question in this grouping. I would say in the strict form of the dispute resolution, that was the only one. I think another document, I'm just going to put this in the chat, just kind of worth looking at, the sort of question sets and then the scope outlines, which talk about the types of questions. So we have the sort of exam type questions, but these content scope outlines actually show, and I'm just going to share my screen very quickly to show this. You can see this is the document. This is the link I just provided. It's the content scope outlines. And so what it goes through is what's going to be tested, both as to the substantive materials and areas, but then also the skills. And when you go down to, I think I'm getting a lag, but if you go down to the skills and you go to client counseling and management, although the actual question sets only have one question, you can see here, these are the types of questions that are going to be potentially used in other questions. Now, as I said, this content scope outline is the current one, right? This could be expanded to deal with other things like what Donna mentioned about reservation points. But right now, this is sort of the types of questions that fall under this foundational set of skills.
This is Peter again, and let me interject the second code, okay, which is BAR, B-A-R, BAR. I suspect that I'm not speaking only for myself when I say that I was hoping that, there's a nasty, vicious circle in our field, which is that client counseling, negotiation, mediation tend to be marginalized in a lot of curricula, and the reason we're given is, well, it's not on the bar, it's not. We don't need to make sure that our students are proficient in that in order for them to pass the bar. And there was this sort of hope, wasn't there, that that this would take a more central role in NextGen by way of overcoming the concern that negotiating or helping your client attain what their objectives are in a conflict, that indeed, skills in that would actually be valued, that they would actually be sought to some level of competency. And I'm having a sense, listening to you, that that may not be so.
Well, look, I think we can all be cynics about this, but let's remember something. I think there's actually something else radical that's going on in the NextGen that hasn't gotten enough attention. It's not really the subject of this discussion, since we are talking specifically about ADR skills, but simply mixing doctrine is already wildly radical, right? I mean, the idea that you can't do criminal law without knowing how to do plea bargaining, but you also can't do criminal law without knowing criminal procedure. You can't do criminal law without knowing the rules of evidence. Lawyers move seamlessly among these things in ways that students do not. Students feel like, I'm taking my evidence class, I need to know what I need to know for evidence, and then I finish my evidence class, and I hope I never have to think about evidence again. I know somebody tells me that I have to review it for the bar exam. I'll think about that at some other point. The simple fact that we're going to be moving among different doctrines, let alone between doctrine and skills, I would love to see that be a way of reorganizing all of legal education. If I had my way, nobody's going to give me a law school and ask me to run it. But if I had my way, we would be doing that already, right? Imagine a law school in which you learned civil procedure by litigating a tort. And you learned criminal law and evidence simultaneously by doing research and writing motions in limine, and then having an evidentiary hearing. And then, if that wasn't entirely successful in discriminating in getting rid of the case, you also did restorative justice before proceeding to try the crime. That's a law school I would like to attend. That's a law school I would like to teach it. I understand that is a terrifying law school because we don't have textbooks for it. Everyone feels like they're not competent to teach it. It feels like we need to cooperate together because none of us have the expertise in all of these things. But I am frankly a little tired of listening to law professors who've been teaching for a very long time in doctrinal subjects say that they can't possibly tackle something as basic as client counseling and interviewing. Because that seems like either they're being disingenuous when they say that they don't have the proficiency to teach that, or they're not being disingenuous and they don't have the proficiency to teach that, in which case I question whether they have the proficiency to be teaching law students. Because it does seem to me a fairly basic thing to be able to use the material we study in law to actually work with real people in real situations. I see that we have some more questions.
Yeah.
One of the things that I had wanted to ask, and so I guess I'll just throw this out to Hemanth, is what I just described was the radical law school of my dreams. I don't actually expect that the radical law school of my dreams is about to happen next week. But Hemanth is, you may not have caught this in the initial introduction, but he's the academic dean at his law school, which means that it's his job to oversee the entire academic program. How do we move a little closer to this, even if we don't get to blow everything up?
Yeah, it's a really good question. It's I think we have to start to think about how to bring in people into law schools who are kind of have that mission, right? And some of that is bringing in people who practiced law and sort of see the benefit of this kind of teaching. But I am seeing more and more of the professors, not just new professors, but professors who've been teaching for a long time, starting to lean into experiential work in their doctrinal courses. I think the hard part with all these things is the load, which is when you have 100 people in a class and you ask them to work on something, are you going to give them feedback? But I have found the pedagogy of composite feedback, group discussion on hypotheticals to be something that works. And so some of it is kind of teaching, and I've been working on this, but teaching some of my colleagues how to do this in a way that's manageable, not them, on Friday night trying to, by Monday morning, correct 100 papers, which kind of, I think, is some of the pushback against this kind of experiential learning in bigger classes is based on that. It's not based on the people don't think it's important, but Yeah, I've been trying to kind of talk people through ways to do it, which is which has always been my goal. I will also say, I just saw one of my former students, on here, and now I feel a million years old. But
Well, let's get a
Tom, nice
different
to see you.
question then, because this is one thing that concerns me, and I don't feel like we've answered this properly, which is, I mentioned earlier that the bar exam is to test minimal competence, basic competence. Let's notice that that actually is far from the excellence that we all want to strive for, right? I mean, there's no time I've been in court or been in class where I wouldn't leave and say, if I did a great job, I'm happy, but I would probably still give myself an A- at my best, because I'm always interested in what else is there. When we're emphasizing the basics, does that run the risk of being satisfied with the basics rather than, as a clinician, you would say to your students, this is good and I want you to be proud of your work, but let's also talk about what else could have been a little bit better. Do we run the risk of letting the little bit better go by simply because the test itself is emphasizing what's basically competent in the practice of law and in working with people?
I will say too, running a clinic, I am the thing that I'm seeing that students really need to work on, and it's actually not shown in one of the foundational skills, but I think a couple of people's questions in the chat, people picked up on that it is underlying a lot of this, which is like close reading, reading comprehension, but close reading. I am seeing in my clinic that is one of the areas that my students are the weakest in. It is attention to detail, close reading, reading comprehension. And to me, those are the things that practicing lawyers really need to do. We think sometimes in law that we're maybe above teaching someone that, but I'm seeing in the clinic that those are some of the biggest mistakes, right? If you put the wrong date on a complaint, or you fill out the wrong box on an immigration application, those things have massive consequences. And so you're seeing at least some of the strategy questions and analysis questions are about, and I think that's a big part of ADR as well, right? Did you listen to your client and what they said? And then did you proceed based on something different than what was said? And it is one of the things I think people are picking up on. It's not listed as a foundational skill, but I think it's underlying all or many of the questions that you see. And at least in part, I think it's partly these things are making everybody's attention to detail much worse. It's the constant code switching between multiple tasks that is creating that. So it is something, at least in practice, I'm seeing. I don't know about the rest of you and in your practice teaching.
I wonder if I could weigh in, Hemanth and Kris, with a proposition that Kris and I have talked about in a Talk to Death. It is my view, and I'm not alone, that the only skill that is shared by every lawyer in every practice is the skill to negotiate. That every lawyer, no matter what they practice, will need to negotiate with a counterparty on behalf of their client. And yet negotiation is not a required course, although property is, and contracts are, and torts is, and even evidence, which is of questionable utility unless you're a litigator. Yet negotiation is not required. Now, is it a nutty thing from your point of view, having studied what the minimal requirements of a lawyer are? Is it a nutty thing to advocate that there needs to be a 3-credit course in negotiation in order to get a JD in this country?
I think it's going to happen, honestly. I think it will happen in one of two ways. It will either be required or it will be a class everyone takes because it's on the bar exam and because it's a big picture class. It's not a simulation type class. And you're seeing in some schools that they're requiring it. But one of the things we didn't talk about today is that 3 different subjects are substantive subjects are being removed from the bar. The NextGen bar exam. And so to me, what that opens up in student schedules, it's like one of the most exciting parts is, so I took trust in estates, not because I care about trust in estates, but because it was on the bar exam, right? That is not going to be tested on the bar exam now. So I think the negotiation class, however, that I think a lot of schools are going to now have to run because of the bar exam, either will be required as some of these schools are doing, or will de facto be required because people are going to take that instead of some other course for the bar because that's not on there, right? And you see that with a class like evidence that's taken by so many people.
And
Partly on the bar,
has there
and
been
partly,
dialogue among your colleagues with respect to how one assesses skills of negotiation? As a teacher, I find it very, very challenging. But my guess is that you have been dealing with people who are a lot more experienced. If it's going to be on the bar exam, how can you determine whether somebody is doing it in a competent manner?
I gotta be honest, I don't think that's what the new bar exam is gonna
Yeah.
do. I mean, I think it's gonna do something different. For example, I teach a course that is entirely negotiation, counseling, interview. In fact, that's what it's called, negotiation, counseling, interviewing. That is focused on what makes for excellence in each of those activities. But when I teach first year contracts, I have my students all negotiate. I don't teach them anything about negotiation. Honestly, I don't even really care what they negotiate. I'm doing it for an entirely different reason, which is the sort of slightly competitive part of negotiation they get into. And it forces my students to carefully review a very long contract that I want them to read and consider carefully. In other words, it's a motivator. It gets them interested and invested. And it does get them to think through and understand sort of problem solving from a client's perspective. Simply being enrolled changes the way that lawyers approach legal information, I find. You can give people facts and law in a dry way, but the minute you put them on a side, they have a different perspective about what to do to that. And I find usually a much more engaged and much more thoughtful perspective. So I think it's going to do that. I think it's going to get people to look at doctrine the way that lawyers in practice use doctrine. But I don't know that it's going to teach them to be, sure, you can say that they all have to take a negotiation class or not, because everybody needs to be familiar with what a BATNA is and needs to be able to articulate it. But honestly, with the bar exam, what a standardized test can do is see, can you evaluate that in light of specific facts and in light of specific law? What it can't do is to say, how can you do the best job in this room with that counterpart having this conversation? But the very fact that we're moving toward an exam that prioritizes those things, and the fact that for generations, alumni have been saying back to law schools, hey, you know what? I wish I'd learned that in law school, and I wish your graduates that I want to hire would know that, might be moving us in a direction where it happens. Because up to now, the argument has been that's taking away time from what we needed to do to prepare for licensure. Now it isn't. So at the very least, that's becoming an artificial barrier that we can't use. What we do have to do is say, hey, how do we want to educate our graduates to practice law? What does that mean? What does that look like? But now I'm going to throw the toughest question at Hemanth so that I don't have to answer it first, which is, I don't know of any design of any standardized test that has ever existed that does not create advantages for people coming from more privilege compared to people coming from less. Now you can design around that, right? Like IQ tests that are determined to have a gender difference are redesigned so that they won't. You can do that. But is this going to do a better job or a worse job or neutral, or is it simply replacing one set of problems for another? Because we know that the current design of the bar exam has always extraordinarily advantaged students who come from more privileged backgrounds compared to others. You're still muted.
Yeah, I think my hope is two or three things. One is I know NCB is focused on this, and so these are, I think, the questions to ask NCB at conferences, and they're going all around the country to conferences, to different law schools, to talk about the next gen exam. So I think that that's a question for NCB, but certainly I know it's one they're focused on. I think the second thing is my hope is that the sheer amount of memorization, the sheer amount of you have to take a $4,000 bar course that digs into every detail of number of areas of law and how to answer the questions. I think the hope through NCBE is this sort of somewhat pared down exam that's focused more on skills you pick up along the way for 3 years rather than jamming information into your brain in 6 weeks or 10 weeks before an exam, will lead to potentially the prep courses not being either as necessary or as intensive, which might reduce the cost. Even the exam itself, we didn't mention this today, but the exam itself is going to be shorter. Before it was 2 full days. Now it's going to be a day and a half. So I think reducing those things, and then also last thing I'll say is NCB is going to produce kind of outlines and different information that might at least take the place of some of the materials that people will have to pay for. So I think those things, at least in terms of financial issues, essentially the practice of studying for the bar exam is now essentially for most people a full-time job for the entire summer. And so what that really harms people who have children, who have childcare issues, who have to work while they support their family. They can't just take off 10 weeks. And I think the hope is the exam being kind of pared down in some ways will help with that.
We have only 4 minutes left. So let me just ask one other thing that Dan mentioned, a concern that I hadn't thought of. Do you anticipate that there will be a disproportionate impact with respect to rates of passage?
I am heavily involved in communities that talk of educators that talk about bar preparation. And so I hear that fear is strongly out there. There's a very big concern that the transition period is going to be particularly hard. And my suspicion is that the NCBE itself and the bar examiners are aware of that, and that's one reason that as I said at the outset, the expectation is that the NextGen is going to get next-genier over time, and that the sort of ambitious goal that it has may not be fully in place in the first couple of iterations. That may look a little bit more like the way that the current tests are designed. I do think that we've seen that the bar examiners are both aware of, but not always as responsive as they could be to the needs of graduates. We saw that with the very complicated handling of bar exam during COVID, for example. So I think that there may be some problems with it, but I do think that they will probably adjust some of their scoring and expectation for the first few years to accommodate that. I think that if they suddenly gave a test and only 50% of people passed, there would be a revolution, and they know it. So I'm not as worried about that. I am concerned about.
Can I jump in on just that?
Or one thing that Jean raised, and I'm going to toss it to you to close us on this, because Jean Sterling, for those who didn't see it in the chat, expressed some disappointment and frustration, which I think we share. But I want to have a little bit more positive spin on it. The bar exam no standardized test that people take only with pencils can replicate how people talk to each other and deal with each other. And the practice of law is an ultimately, at its best, deeply humanistic, engaged profession that involves working with real people. A pen and pencil test cannot do that. But what it can do, and what I hope it will do, is break down the sort of institutional barriers that have kept us from addressing that in legal education overall. My current law school, New York Law School, is, for those of you who are not aware, a spectacular law school, but I would not describe it as elite. Before I came teaching, I did teach an elite law school. And you know what? Law professors learn very quickly. You cannot use the word skills in some hallowed halls, because God forbid that anybody acknowledge that you were teaching people who are going to practice law the skills that they would need to know to practice law. Now, I think that's silly. I think that everybody needs to know how to work with their clients, with other lawyers and everyone. And I do hope that sort of breaking down doctrinal barriers, breaking down differences between skills and information and doctrine is a thing that has to be a movement in the direction that we all want to be, and the direction that we all want to go. So Jean, I share your frustration, and you're probably getting that from us, but I do also have a hope that all of this simply has to be better than where we've been. So saying that, I'll toss it to you for the last word on that.
Yeah, I mean, I think a couple of things. One, just a reminder that states individually set their pass rates. So NCB really isn't involved in that aspect. It's every state picks a number in the UBE, right? States pick numbers for what is a passing score for that state. So I don't think you'll see a massive drop in bar passage because states will have a control over that, and it's certainly not helpful for them to have massive drops in bar passage. I like it's nice that we didn't plan it, but Carolyn's kind of message in the chat, which is kind of this excitement about what it looks like to do these different types of questions. I think this is the first step, as Kris has said a bunch of times. I think it's a great first step. I think all of us who do social justice work know that you don't get everything you want in the first bite, right? So I think this is a massive, massive change. It's a massive step forward. But I think all of you and your kind of comments are help NCB figure out, okay, what can we do to add to the negotiation and ADR elements that we have in the exam? How can we make the questions better? So it's going to be up to our community to start to influence and work with NCB to figure out, well, how can we do this better? Everything I know from all of the conversations I've had with people on NCB for the last 3 years is like, they want to know, what do you all want, right? And so this is a first step in many, but we're all going to be part of, I think, the process of making this exam even more realistic, more helpful, more of a training ground for future lawyers to be able to practice law in ways that help our communities.
Well, I thank you both, and I think it's entirely appropriate to end the conversation on a note of engagement and forward-looking as you have. The last code for everybody is exam, EXAM exam. Well, that's provocative, and it went away that I, for one, didn't anticipate, and I learned about things that I just didn't understand before, and I'm very grateful, and I'm sure the rest of us are grateful as well. I want to mention to everyone that on the 19th of March, we're offering our next ADR CLE program, which has to do with the use of mediation in franchise. It's an area that's I'm particularly tender to, because it's a business model that relies upon collaboration and the creative resolution of disputes between franchisors, franchisees, much, much more than most business models do. And as a result, there are people engaged in that industry who are really experienced and really principled on the way mediation works in a commercial context. So I encourage you to look for that. It's the 19th of March. Thank you to both our speakers. Thank you to everyone for attending.
Thanks, everyone.